Acceptable. Adjournment.
Yes, please.
May I please, Your Lordship? I beg to mention item number 8 of the list, Your Lordship. This item has become infructuous, Your
Item number 8.
8. It's infructuous, Your Lordship.
Come infructuous.
Yes, Your Lordship.
Other side, TJ Mohantos Jr., anyone is here? AEGCL, anybody is here? You should have informed them. They could have been also here. Why don't you get them? It's item number 8. Get someone from the other side. I will close it.
May I please, Your Lordship? For item number 3 is concerned, Lordship, it is becoming infructuous. What? 3.
3 is, I think, cooperative.
Property.
Anyone there? Why don't you have the presence of the other side counsels if you are mentioning out of turn in an infractious matters? Yes. Yes.
She is there.
Item number 3. 3, right? Heard, Mr. Yes.
Ardhar.
Ardhar, learned counsel appearing for the petitioner as well as MS,
ST Bhakt.
SK,
Bhakt.
Bhakt, BA,
BOKTH.
KTH, SK, na?
ST.
ST Bhakt, huh? Learned standing counsel, cooperative. Mr. Dhar, learned counsel for the petitioner, submits that this writ petition in the meantime has become infructuous and accordingly makes an endorsement to the same effect. In view of the aforesaid endorsement, the writ petition stands dismissed on being infructuous. Disposed of. Any interim order is there?
No.
Yes, please.
Lordship, I beg to mention item number 2.
Yes.
I beg adjournment today.
It's item number 2 is a 2016 matter, ma'am. Please wait. Item 2 will be called immediately. We will not keep you waiting for a long time. Yes.
May I please, Your Lordship? I beg to mention item number 7, Lord.
Yes.
Matter may be possible for that 2 weeks time may be granted, Lord. We will file additional affidavit.
You are for
Petitioner,
as prayed for by Mr.
J.H. Laskar.
J.H. Locker, learned counsel for the petitioner, relist after 2 weeks on a date to be fixed by the registry to enable the petitioner to file an additional affidavit in the act.
Okay.
Yes.
May I please, Your Lordship? My lord, I beg to mention item number 11, my lord. It is infractious, my lord. Petitioner got the relief, my lord.
Government is there? Yes. Heard Mr.
Please check, my lord.
T. SK.
Yes.
Learned counsel for the petitioner, also heard MS Udas, learned additional senior government advocate for the state respondent. Mr. SK, learned counsel for the petitioner, submits that this writ petition in the meantime has become infractious as the petitioner has already got the relief as sought for in the writ petition. In view of the aforesaid endorsement, nothing survives for adjudication in the instant writ petition. Accordingly, the writ petition stands dismissed on being infractious. Disposed of. Any interim was there?
No, my.
May I please, Your Lordship? Lordship, I beg to mention item number 21.
I remember.
21.
Yes.
Lordship, I praying on behalf of Senior Counsel Mr. K. Chaudhary.
What do you
pray-
want?
I pray for accommodation for today, Lordship, due to personal difficulty.
Yes, government as prayed for by Mr.
S.A. Bhaktiyar.
S.
S.A. Bhaktiyar. My name is not here.
Your name is
For
not there.
K. Chaudhary.
You are there in this? Pala number. By so and so on the ground that the leading counsel, the leading senior counsel, the senior counsel leading the brief, Mr. K. Chaudhary, is out of station.
Personal difficulty.
Is having personal difficulty today. Prayer is not opposed. Relist after
Vacation,
2
Lordship.
weeks on a date to be fixed by the registry.
That is the Lordship. Lordship, with the consent of the petitioner, Lordship, I beg to mention item number 24.
24.
Yes, Lordship.
Yes.
My senior Mr. S. Committee is out of station, so Lordship kindly may adjourn the matter for the day.
MS
R.R. Saikya.
R.R. Saikya, learned counsel on behalf of Mr. S.K. Mehdi, learned assistant, learned CGI.
CGC.
CGC, sorry, learned CGC for the state for the respondent, mentions that makes a mention for adjournment with consent from the other side. Prayer is allowed to relist after 3 weeks on a date to be fixed by the registry.
Obliged, Lordship.
Eight.
Please, Your Lordship.
Yes,
Please,
please.
your lordship. Lordship, I beg to mention item number 39. Lordship.
30,
39, lordship. Lordship may kindly accommodate for a day, lordship.
39, what do you want today?
Lordship, adjournment, lordship.
Adjournment. This is RSA. Okay.
Lordship.
Uh, your name?
P. Bodley, lordship.
As prayed for by Mr. P. Bordoloi, learned counsel for the appellant, relist after 2 weeks on a date to be fixed by the registry.
Lordship. Oblige, your lordship.
May I please, Your Lordship? I beg to mention item number 16 and 17. 16
P
and
and
17.
17. Yes, what do you want?
My senior, she is in Delhi for her knee treatment, so kindly pass over the matter and let
You are
it
for the
be-
petitioner.
Yes, Your.
Government.
Madam.
As prayed for by Mr. Sorry, by MS. Your name.
My name,
Yes.
it's Avisha,
Uh,
Avihra.
pala?
Madam.
Lordship,
Rupak loi lobo. By
Lord-
so and so learned counsel appearing for the petitioner.
Yes,
Which is not opposed by the other side, released after 3 weeks on a date to be fixed by the released after 2 weeks on a date to be fixed by the
Lordship.
registry.
I pray that the interim order passed earlier may continue.
Interim and Fanny shall continue till the next date. Yes.
May it please the lordship, I beg to mention item number 38. Lordship may kindly be pleased to adjourn the matter for the day. We have filed an additional affidavit in this matter.
38. You are for the petitioner?
Yes, my lord.
Government GST Standing Council, have you informed?
Yes, ma'am.
You've informed.
Yes, ma'am.
Mr.
D. Rathi.
D.
Rathi.
Rathi, learned counsel for the petitioner, submits that an additional affidavit has been filed in the matter. When?
My lord, within previous week. Witness.
As prayed for by Mr. D. Rathi, learned counsel appearing for the petitioner with consent from the other side, relist after
2 weeks, ma'am.
2 weeks on a date to be fixed by the registry.
Much obliged.
May it please, Your Lordship, I beg to mention item number 4, Lordship. Matter is become infectious, Lordship.
4.
4, Lordship.
Yes,
item.
government. MS, your name?
J. Ghosh.
MSJ Ghosh, learned counsel for the petitioner, submits that the matter in the meantime, that the writ petition in the meantime has become infructuous and accordingly makes an endorsement to the same effect. I got petitioner for petitioner, I will Mr. J. Hendik for additional senior government advocate for the state respondent political. In view of the aforesaid endorsement, nothing survives for adjudication. Writ petition accordingly stands dismissed on being infructuous.
Oblige, Lordship.
Disposed of. Yes. Are you planning to make steps or should I dismiss it?
Your lordship, matter is infectious.
Infectious?
Yeah.
Oh. Yes, government, anyone, revenue, anyone?
What is
Heard your name?
MUE Bhuya.
MUS Bhuya,
MUE
MUE Bhuya. Learned counsel for the petitioner, also heard Mr. J. Hendik, learned government counsel for the state respondent, and Mr. A. Bhattacharji, learned standing counsel, revenue and disaster management department. Mr. So-and-so Bhuya, learned counsel for the petitioner, submits that the matter in the meantime has become infructuous and accordingly makes an endorsement to the same effect. In view of the aforesaid endorsement, nothing survives for adjudication. Accordingly, the writ petition stands dismissed on being infractions disposed of.
Oblige.
Any interim?
No, lordship.
I don't know. In item 2, you were saying something?
Yes, yes, Your Honor.
Yes.
I want I beg for adjournment, Your Honor.
Why?
Because the parties not coming to us or not contacting us even. We have
Yes, Mr.
tried.
Goswami, Mrs. Hendik,
Lordships.
what is this matter? No evidence also filed?
Matter regarding my lord ethnic violence. They are seeking some compensation. Earlier, my lord, as per annexure 12, my lord, similarly situated, but some person has been, my lord, moved before filed before this, my lord, honorable court. My lord, that was rejected by this honorable court.
Page?
Page, I think, lordship 60. Page 60, Lordship.
Page?
60, Lordship.
I think 57. Justice Kotoki's order.
No, in partial to that order, my lord, one speaking order was passed.
Oh, acha. Yes.
Some rehabilitation grant was given, Lord. Serial number 1 and 2, Lord.
Why don't we also direct an inquiry, and this was the direction earlier, isn't it?
Lordship, it was
Keeping in view the aforesaid position, the
Annexure 11, my lord.
disposed of directing the additional Chief Secretary Revenue and Disaster Management Department to cause an inquiry relating to the claim of the petitioners and to pass a speaking order in this regard.
Lord.
The said exercise is to be completed within a period of 2 months from the date of receipt of the certified copy of this order, along with the copy of the writ petition with annexures appended thereto. I think a similar order can be passed. What is the point of keeping this matter pending here?
Nothing, Lordship. My lord, the unnecessary 2019 is
I think it's a 16 matter,
Lordship.
and nothing more can be done also besides passing.
My
this
lord,
order.
already, my lord, as per the, my lord, that order, Lordships of the Honorable Court, the
Yeah,
page
You are right,
11.
but you see, page 60 order relates to that particular
That
petitioner.
Lordship, the Annexure 11, page 57.
Is relatable to this petitioner,
Lordships.
is it?
My lord, that some similarly situated person has been approached.
11.
Annexure 11, page 57.
That's the order I have I read.
Lordship.
Page 58, you see?
Lordships.
Page 58.
58, Lordships.
Read that direction.
The keeping view of the aforesaid petition, the writ petition is disposed of directing the additional Chief Secretary Revenue and Disaster Management Department to cause an inquiry related to the claim of the petitioner and the past speaking order regarding in this regard. The said exercise will be directed to be completed within a period of 2 months. 2 months from the date of receipt of the certified copy of this order, along with the copy of the writ petitions with the annexures appended there to be filed by the petitioner before the additional Chief Secretary Revenue and Disaster Management, Relief and Rehabilitation Branch. If it is needless to say that if the petitioners or any of them are found to be entitled, the receipt of such amount, necessary step or payment shall be taken within a period of 2 months.
Isn't it?
Lordship.
Now here, this is BT, this is which area?
This is also BTA.
So who will be this direction has to go to whom? To the respondent number 1. Please have a look at the cost item.
Lordship. My lord, they did not make a party, my lord, at BTAD, I think. BTAD, they did not make party.
Yes, so who has to make it, the inquiry? The direction has to given to whom ultimately?
Ultimately, Lordship, respond number 1, Lordship.
1. If we give it to 1, I think it can be done.
Can be done, Lordship, but even then they are fall under the BTAD, my lord, BTAD will be.
So 1 has to,
I have to, my lord, he have to have communicated, my lord, whether my lord BTAD has been proceed or not, my lord, it is difficult to say.
no, then why don't we have someone from the BTD in court? We can add them.
Let me fix it some other that I will inform them, my lord, BTAD. day after tomorrow.
No, but can we not add them as a party?
But they have to file a petition, my lord. Otherwise, my lord, it is difficult.
No, but the problem is this matter is pending since 16.
16 lord.
She is not in touch with her clients.
When, my lord, it is the second time it has been less, my lord, after
Huh?
it was less after a long time, lordships. My lord, they have to, my lord, take interest on the petition, my lord. They similarly, order has been passed, lordships already. They can approach. I think it is second or third time it is been listed.
You see, you have not made the BTAD a party.
Your lordship, I also don't know, I also.
So you find out because then otherwise I was ready to dispose of this writ petition. There is no point of keeping this writ petition pending. The only order that you can get from this court is to direct the concerned authority to make an inquiry as regards the claim. Correct? This court cannot do it, and this court cannot direct them to give you. Some inquiry has to be there, and based on that inquiry, the competent authority will do whatever is to be done on the fate of the inquiry.
Lordship.
That is the only order that you will get. Now there is no point of pending, keeping it pending. It's already pending from 2016.
16.
Isn't it?
Yeah.
So, but you have not even made the BTAD a party. This belongs to Kokrajar Revenue Circle.
Lordship.
They are the competent
They are
person.
the competent authority, lordship. They
Unless you make them a party, even if I dispose it of granting the Secretary Department of Relief, they will not be interested because they are not a party.
No. I understood, your lord.
So you do whatever is to be done. Your name?
Pompa Chaudhary.
Heard MS P. Chaudhary, Learned Counsel for the petitioner. Also heard Mr. J. Hendek, Learned Government Counsel appearing for the state respondent. It appears that the relief sought in this writ petition is for a direction to the respondents to pay the compensation and rehabilitation grants allotted in the name of the petitioner as per assessment.
My name is not reflected, but we are there. Revenue is also.
No, but if we direct it to the revenue, can this be done without the BTAD presence? They will be required, right?
They will be required, my lord.
Allotted in the name of the petitioner as per assessment list prepared by the respondent number 4, the circle officer Sidley Revenue Circle in the district of Chirang, BTAD, and or pass such order or direction. Full stop with. But you see, the revenue circle has Chirang has already, and this revenue officer comes under you.
No, it comes under BTA.
It appears that the BTAD, that BTAD is not made a party in the instant writ petition. Let MS so-and-so obtain instruction and do the needful in this regard. Unless BTAD is made a part, unless BTAD is made a party in the instant writ petition, no effective orders can be passed. That's it. Take it and list after 2 weeks on a date to be fixed by the registry.
I think.
Highly obliged. Sir.
আমি কি করে লিখবো?
359 স্যার আপনার নামটা কি?
Item 21 at লিখে দিবা. Any interim, if any, shall continue in the next year. Item 21 at already 2 weeks দিয়া আছে নি? না? Yes. Item 5, ex gratia. Affidavit is there. Not entitled. Where is he? All right, we'll keep it for some time. Let's see. Eto ako matiba. Jun nai eto recall kori diba. Just go on. Nine. He's a legal aid counsel and he's not here.
Not here.
Very strange. If legal aid counsels are not appearing when matters are called, it's very unfortunate. You wanted to take some time.
No, Your Lordship, the matter has become infectious.
Oh,
Matter has become infectious.
your name?
K. Kashyap,
Heard Mr. K. Kashyap, Learned Counsel appearing for
the
the
petitioner.
petitioner.
Yes, Your Lordship.
Mr. So-and-so, but your name is not there.
Yes, my senior's name is there, Mr. NNB Chaudhary.
Appearing on behalf of Mr. NNB Chaudhary, huh? So-and-so submits that logo K. Fukan, na?
K. Fukan.
K. Fukan.
For respondent number?
Learned additional senior government advocate.
No, I'm for AGCL. He is appearing for government.
You are for AEGCL.
For respondent number 2 and 3, Your Lordship.
R2 and 3, Standing Council AEGCL.
Yes, Your Lordship.
And Mr.
Talukdar,
Talukdar, government advocate
Lordship.
for the state respondent. Mr. So-and-so Kashyap, Learned Counsel for the petitioner submits that the writ petition in the meantime has become infructuous and accordingly makes an endorsement to the same effect. In view of the aforesaid endorsement, nothing survives for adjudication in the instant writ petition. Accordingly, the writ petition stands dismissed for being infructuous. Any interim?
No, Your Lordship.
Any IA?
No, I.
No, I know.
All right, disposed of.
Obliged.
Much obliged.
Lordship, this matter came after a long time, Lordship. After motion, this is the first time. I pray for some time to obtain the instruction, Lord.
All right, fair enough. As prayed for by Mr. S.S. Roy, Learned Government Counsel for the state respondent, relist after 2 weeks to enable the state to file their return in the matter.
Lordship, let it be 3 weeks, Lordship.
3 weeks.
Highly obliged.
9. Silo, but
Same, item 10, same, they are not entitled, Lordship, for not there.
ask for, just send a message to the petitioner.
12 is also
number
stable.
send to your message. Note did you? Yes?
12 is same.
12, who is there? Maybe they know they're not entitled.
That's why, Lord.
Mr. Roy, when I recall the matters, you remind me, huh?
Lordship.
Land acquisition compensation.
No, Lordship. MSC team, motor accident.
I think 12. 13.
Motor,
13.
13 is
May
Lordship.
your lordship, please, my learned senior counsel is another court. Maybe possible for timing.
13, I think, is land.
13 is land acquisition. Lordship, here last occasion, they were asked to file the reply and serve a copy.
Have they filed?
The copy was not served to us.
Have you filed your reply?
Yes.
You have
Cop-
filed.
Copy
But
was
they
not.
have not got a copy. Please give a copy. Mr. MS?
MM Das.
MM Das for petitioner, Roy for state, huh? You are appearing. Your MS?
M Das.
M Das for
PWD.
PWD, or A Bhattacharjee is also there. Revenue. Mr. Roy submits that though the petitioner was supposed to file a reply, however, the same has not been served to them till date. MS so-and-so for the petitioner submits that the affidavit in reply has been filed on 24/4/2025. Let a copy of the same be furnished to all the learned counsels appearing for the respondents if the same has not yet been served. Furnished. Relist next week
Lordship.
on a date to be fixed by the registry. Ma'am, have you understood? You give a copy to Mr. Roy. Yes.
Here I pray 2 weeks time for filing my reply.
Reply.
2 weeks time.
Mr.
Yes, sir.
S. Natna,
My lord.
learned counsel for the petitioner seeks 2 weeks time to file rejoinder against the affidavit in opposition filed on behalf of respondent number 1 to 6.
Lordship. Right.
Okay, very cool. Prayer is allowed, then relist after, but as prayed for social good. Relist after so and so on a date to be fixed by the registry. Yes. Second time মাতিবা, second time dismiss কৰি দিব পাৰিম।
Please, your lordship. Lordship, matter is regarding dismantling of our hoardings by the GMC authority on the account of non-payment of
Mr.
license.
Chaudhary, sorry, what is it?
Dismantling of our hoardings,
Dismantling of your hoarding
hoardings by the GMC authority
for
on the account of they are alleging that we have our hoardings are illegal, so which we have not paid any license fees or tax to the GMC authority.
affidavits have been filed.
They have filed their affidavit.
You are filing reply or you not?
Not necessarily, lordship, it's on a legal point, lordship only.
Okay. So can we take it up now?
Lordship, but they are
Who is appearing for GMC?
CMC earlier, M. Haloi was appearing and thereafter S. Bora is here.
When petitioners are not there, the respondents are there. When respondents are not there, then the petitioners are there. How the court will function, tell me? Very difficult. Heard Mr. D. Chaudhary, learned counsel for the petitioner. None appears for the GMC respondent on call. Are you for GMC? Mr. Borpujari, are you there in GMC? Relist, the names are shown.
Lordship,
When do you want it? Monday? Relist on Monday.
interim order passed.
Interim, if any, shall continue till then.
Much obliged.
তোমার চেঞ্জ করবে ইয়াক চেঞ্জ কৰিবলৈ লাগিলে কৰি দিব হৈছেতো বহুত পালা কৰিম
My lord, these matters are already covered by the.
Get hold of your counterpart. If the matters can be disposed of, I'll recall them, so you get him. What has happened today? Where are all the councils?
Yes, my lord.
Huh?
Shocking, my lord, na. Most of
Very
the
shocking.
cases- Yes, my lord.
It will
Most
be
of the
more shocking
cases-
when on the second call, if nobody is appearing, I dismiss all the matters.
Most of the cases are
This
100%.
is unfortunate.
Not-
There are few of them are old matters.
Yes.
Madam, second time, এইখিনি চেজ কৰি পিনে second time কৰো 38 লৈকে কৰি লওক আগতে You are appearing in 30.
For BTC. For BTC, yes, for BTC.
30, anybody appearing for the petitioner? No.
I'm item number 28 and 29, my lord.
28, you are for the petitioner?
Yes, my lord.
28, you are there.
yes,
So
yes,
28 to 2. Why are you not here when the matters are being called? Huh? You are making it look like as if this is some, this is not a court. You will come in whenever you feel like. You must keep a track. Yes, Ms. Das, what is this?
My lord, they also hired.
The amount claimed is disputed.
Yes, my lord, disputed. We have admitted the amount. Lordship will find page 45. We have admitted 11,41,928.
11 lakhs?
41,928, page 45 of our petition. We have given the breakup.
Yes.
So this we have admitted, and we have denied the hiring of vehicle number AS 18B2772. It was never hired. So my lord,
And this 11 lakhs is paid.
my lord, not paid, my lord. As and when my lord fund will be.
What do you mean
released.
by as and when?
My lord, that
As and when funds means?
by the police headquarters, my lord.
Where is that admission and page 25 you said?
My lord, our affidavit, his lordship, is it starts from 41. We have admitted the amount at page 44, paragraph 5. We have denied hiring of a
Page
vehicle.
45.
Page 44, paragraph 5.
Something is wrong.
My lord, then
Your affidavit
affidavit.
this is additional affidavit. Then
Affidavit in opposition, my lord, filed on 10/1/25.
affidavit in opposition
It's,
filed on 10/1.
yes, my lord.
In this affidavit, paragraph 5.
Paragraph 5, my lord. 4th page of the affidavit. We have denied the hiring of vehicle number A0118B2772. We have denied. And that's why, my lord, 20,89,303 we have denied, but we have admitted the amount this page, my lord, 11,41,928.
Who is going to give you the funds?
My lord, from police headquarters, my lord.
Huh?
The respondent, my lord. Women political women political no, women political. My lord, that is from 3, my lord, respondent number 3.
Who is appearing? You are appearing.
My lord, 1 and 3. Yes, I'm appearing. So maybe my
Very
lord,
well, I'm
direction
disposing it
may,
off.
direction may be
Yes, yes.
within 4 months. my
Yes, yes.
lord. No, deeply obliged.
This is item number 28. Yes, I'm disposing it off. Because as far as the admitted amount, I'm saying within 4 months to release. All right. As per the disputed, this court is not the forum. You go before the civil court.
A Hussain.
Sorry?
A Hussain.
Heard Mr.
A Hussain.
A. Hussain. Hussain, learned counsel for the petitioner. Also heard MS Udas, learned additional senior government counsel for the state respondents. By way of this writ petition under Article 226 of the Constitution of India, the petitioner is seeking direction inter alia for release of the admissible amount of money payable to the petitioner amounting to rupees 20,89,303 within bracket words, Diriba, as due to be paid to the petitioner by the authorities on the basis of the vehicles hired by them for requirement, as per requirement basis. Stop. For requirement. The brief facts of the case is that the respondent authorities hired the vehicles of the petitioner, i.e. The brief facts of the case is that the petitioner is the owner of the vehicles bearing registration number AS 18B2772 within bracket Bolero AC, comma, AS 01DC 4693 truck, AS 25CC 5020 Bolero AC, AS 01AC 6697 bus, respectively. Okay? Details to page 6 of Paba, ma underline kori A likhi disu. The respondent authorities hired the aforesaid vehicles of the petitioners on during the period 2015 to 2023 on different dates in connection with maintaining law and order situation, and after use released them on different dates. It is the specific case of the petitioner that the respondent authorities used to utilize the vehicles of the petitioner as per their demand, and after release of the same, they have not paid the hired charges. It is the further case of the petitioner that accordingly a bill of rupees 20,89,303.00 is due to be received from the respondent authorities. Accordingly, the present writ petition has been filed. Heard, perused, Koba. It appears from the affidavit in opposition filed on behalf of respondent number 8 the Superintendent of Police Kamrup Amingao, Assam on 10/1/2025. 25, right?
My lord,
2025.
my lord.
That the respondent authorities have admitted their liability to the extent of rupees 11,41,928 only, both in numbers and words. However, have denied the hiring of one of the vehicles of the petitioner being Bolero bearing number AS 18-B/2772. Apt to refer to paragraph 4, the chart 5 and 6 of the aforesaid affidavit in opposition, which is reproduced hereunder for ready reference, quote unquote. Paragraph, page 50. Affidavit from asset page 50, a green flag. Or paragraph kitna 4 of graphs. 8. B will elect. A reading of the aforesaid averments of the affidavit in opposition, it is clear that the stand of the state government is that the admitted dues of the petitioner is only to the extent of rupees 11,41,928. And due to non-availability of fund, the aforesaid amount has not been released till date to the petitioner. Non-availability of funds cannot be a reason for depriving the petitioner of his legitimate dues. As regards the disputed dues of the petitioner, this court, under Article 2 to 6 of the Constitution of India, cannot go into such disputed question of facts. That being so, this court is of the unhesitant view that this writ petition can be disposed of with a direction to the respondent, particularly respondent number
1 and 4, my lord.
1 and 4, to
4 and 5 also, my lord.
to the respondent authority,
Authorities.
to the respondent authorities to make payment,
My lord.
to release the admitted dues,
Your lordship, please just verify and pay, my lord,
to
because
verify to you have done.
my lord, by the respondent number 8.
You have already said this is,
Lordship, please. Yes.
to release the admitted dues of the petitioner to the extent of rupees 11,41,928 in accordance with law within a period of
4 months.
4 months from the date of receipt of the certified copy of the order.
Obliged.
That should be
My lord, in accordance with
sufficient.
law.
Put it-
Deeply obliged.
writ petition accordingly stands disposed of with the aforesaid direction and all.
Item number 29 also.
Same,
Same, my lord.
down 29 to
Lordship, here in this case also, we have filed our affidavit, Lordship. Our affidavit indicates paragraph 5, Lordship.
paragraph 5.
Lordship. They have claimed an amount of rupees 26,94,373.
One sec, let me first, Mr. Talukdar, let me locate your affidavit first.
Lordship. We have admitted, Lordship.
Affidavit is of which date?
Is of February 2025.
Huh?
13th of February 2025, Lordship. Page 46, filed by respondent number 7,
I
Lordship.
have the additional affidavit, but no, your affidavit I think is not here.
Respondent number 7, Lordship.
Just have a look. Otherwise, we can get that affidavit.
Lordship.
তুমি এইটো লৈ লোৱা। অলপ এক মিনিট ৰখিবা, এইটো similar order হ'ব। এইটো ৰূপক, এই এফিডেভিটখন যদি ৰেকৰ্ডত নাথাকে, গভৰ্ণমেণ্টৰ কপিখন লৈ এখন কল কৰাই দিব পাৰে, ডিছপ'জ অফ কৰি দিলে না। নহয়, মই এইটো কৰি দিব পাৰোঁ, তুমি আনাই ল'বা। আনি লোৱা।
He has not tagged, Lordship. Perhaps not come on record.
But you have filed.
Filed, Lordship.
You sure?
Lordship. I have copies.
You have received?
Yes, my lord.
Oh, he has received.
Lordship.
Then give
Lordship,
me
may
copy.
have a look at my copy, Lordship.
Yes,
May have a
give-
look.
এইটো আনাই লওক। Yes, page.
Lordship, at paragraph 5, Lordship. Page 46, my lord. Our affidavit, Lordship. We have admitted the amount. In fact, they have claimed rupees 31 less. They have admitted
So
31
here
more.
you have admitted more.
More, Lordship. 31 rupees more. 32. And out of that,
No.
Lordship, out of that, an amount is already paid to them. And Lordship may have a look at Annexure A, Lordship.
No,
Towards the down below, Lordship. Their remaining amount is mentioned. That amount may be directed to be released, Lordship.
One sec, one sec. তুমি যোৱা এইটো প্ৰণৱক দিম। প্ৰণৱক মোক দিম। আৰু লৈ যোৱা এইটো। এখন রূপক আপনি এখন requisition খন দি দিয়ক। Just give a requisition, Mr. Talukdar,
Lordship,
calling for this affidavit.
Lordship.
So how much is now due? Where do I get that figure?
Lordship, may have a look at Annexure A. Annexure A.
Yes,
Down below, Lordship.
proposal. The
Some amount is
remaining
already
amount
paid.
of rupees 2629.
Lordship, an amount is paid. After deleting that amount, that much is remaining.
And the total amount is? Total amount is 32.
26.
The total amount should be 26,20,94,405. Again, an amount of rupees 64 so and so has
Got it.
already been paid to the
Towards the
petitioner.
middle portion, the remaining amount.
The remaining
is-
amount of rupees 2629 so and
Got it.
so,
That is the amount.
that is the amount which
We
has
have to
be
pay now.
heard so and so. Ifale also heard R.
Talukdar, Government Council,
Government Council for the
catering for all the
state,
respondents.
for all the respondents, state respondents, huh? By way of this petition under Article 226 of the Constitution of India, the petitioner is seeking inter alia
29.
direction for release of the admissible amount of money payable to the petitioner amounting to rupees 26,94,373.60 as due to be paid to the petitioner by the authorities on the basis of the vehicles hired by them for requirement. The brief facts of the case is that the petitioner is the registered owner of the vehicles bearing registration number AS 25J 2848 within bracket Innova, comma, and AS 01DD 9250 within bracket watershed. Ito papa, page 6A. The respondent authorities hired the aforesaid vehicles of the petitioner during the period 2019 to 2022 on different dates in connection with maintaining law and order situation as and when required. It is the specific case of the petitioner that after utilizing the vehicles, the respondent authorities have not paid the hiring charges amounting to rupees 26,94,373.60 for which full stop. Hence the writ petition heard carused. It appears that the respondent number 7 within brackets, the Commissioner of Police Guwahati, Assam, has filed an affidavit in opposition, a copy of which has been served to the petitioner, wherein it has been stated that the actual amount as per the records available is rupees 26,94,405. And out of which an amount of rupees 64,802 have already been paid to the petitioner with a Assam Police Headquarters sanction number FS/POL 2022-23 within bracket 1/450 dated 4/6/2022. And as regards the remaining
19.
bill upon verification and as regards the balance due to non-availability of fund, the same could not be credited to the bank account of the petitioner. Apt to reproduce paragraph 5, 6, paragraph 5 and 6 of the aforesaid affidavit in opposition.
9 or
Unquote, huh?
9 or 4.
And 9 of the so and so. Huh? Page 46. Okay. Apt also to reproduce the notification dated 14/6/2024, which reads as under, quote unquote, page 51. Notification dated so and so issued by the
Lordship, it is payment status. Lordship may indicate payment status.
The payment status. Apt also to reproduce the payment status issued by the Deputy Commissioner of Police within bracket admin Guwahati, Assam, wide letter dated 14/6/2024, which is enclosed as annexure A to the said affidavit in opposition, which reads as hereunder, quote unquote, page 51. A perusal of the aforesaid payment status indicates that out of the total admitted amount of rupees 26,94,405.00, after an amount of rupees 64,802.00 being paid to the petitioner, an amount of rupees 26,29,603.00 stands currently due to the petitioner. It further appears that the respondent authorities, though has forwarded the aforesaid pending bill of the petitioner to the sanctioning authority. However, since the sanction has not been given due to non-availability of fund, the said amount could not be credited to the bank account of the petitioner. Non-availability of fund cannot be a ground for non-releasing the admitted hiring charges of the petitioner. That being so, this court is of the unhesitant view that this writ petition can be disposed of with a direction to the respondent authorities to release the aforesaid admitted amount, aforesaid balance admitted amount of rupees 26,29,603.00 to the petitioner within a period of 4 months from the date of receipt of the certified copy of the order in accordance with law. Disposed of.
Lordship, that letter is dated 14/6.
14/6.
Payment status.
Please,
14/6
Mr. Talukdar, ensure that this has come, huh?
Lordship.
For some reason, if it is not there, then you ensure it is filed.
Lordship.
Because we have recorded it.
Lordship.
Disposed of.
Obliged.
And I look at it.
Thank you.
Lordship, the matter pertains to non-payment of land acquisition compensation.
Yes, sorry.
The matter pertains
Land
to.
acquisition compensation.
Yes, Your Lord.
Yes.
I have been
Simple
instructed.
instruction.
Affidavits not come.
Simple instruction, my lord. There is a
Title suit
title
pending.
suit pending. That's why his claim cannot be considered. It's simple instruction.
Then,
Lordship,
if there is a dispute to your
Dispute.
entitlement,
yes, Your Lordship.
how can this court in 2 to 6
understand.
go into all this?
I understand, Your Lord.
You want to withdraw?
No, Lordship. It is only after filing of this case that I have come to know that there is a dispute. I have a representation that is pending, Your Lordship.
What is the use?
Because if
Even if we direct the authorities to consider your representation, they will reject it by saying there is a
Yes,
title
sir.
suit pending.
I understand.
How are you benefited?
Only thing, Your Lordship, my client apprehends that due to that, we have submitted all the relevant documents. There is an order in our favor, and there was no objection to the authorities by the plaintiffs of the title suit. Under such circumstances, if they somehow get it disbursed in their favor, that will be a difficult.
What can this writ court do, Mr. Counsel?
This court,
In such disputed question of facts?
this court can take into consideration about the pending case and then direct the authorities to withhold the amount at least till the.
No.
If I withdraw it, Your Lordship, if.
Mr. Counsel, why don't you file this by way of an affidavit? You file it by way of an affidavit, till then let him also
Right.
get a chance. Heard, Mr.
BJ Mukherjee.
BJ Mukherjee, learned counsel for the petitioner, also heard Mr.
RK Musari.
RK Mushahari, learned standing counsel, BTC. Mr. Mushahari submits that he has received the parawise comments and seeks a short accommodation for placing the same by way of an affidavit. Prayer is allowed, relist after 3 weeks on a date to be fixed by the registry. To enable the state BTC to file the return in the matter, huh?
May please, Lordship. This may part of our timing also. Madam, I'm taking off some time also.
Why?
My senior counsel is late.
Affidavit in reply is filed.
Case is ready for hearing, my lord.
What is this matter, Mr. Chutia?
My lord, matter relates to acquisition of the land, my lord. And we have, my lord, filed the affidavit. Reply has also filed. Lordship may hear the matter at any date, my lord. Fix,
I'll admit it then.
my lord, admit,
I'll admit it and post it for hearing in the
My
month of August.
my lord.
Lordship,
This heard, Mr.
Lordship, this maybe this matter may be taken after some after pass of timing also. Lordship, my English counsel is on late.
When let him come. Eviction, Mr. Ahmed.
My lord. If you also kindly say.
Affidavits have not been filed.
Item. We have filed in item 37.
33.
And that will cover the.
You have filed in
7.
33. Item 33, Amala Vivi.
33 to some?
Yes, 33.
It will be cited. Yes.
Page 96, my lord. Paragraph 4. These persons were encroaching upon land in tribal belt and block and they were evicted. Now this is the our substand, my lord, in paragraph 4. May I read, my lord?
Yes, please.
The one begs to state that land records submitted by the petitioners number so and so were verified by the circle officer Sonapur Revenue Circle. And as reported by the circle officer, none of the petitioners were found to be in possession of valid land documents. And on further proper verification, the petitioner are not found to be belonging to protected class as per chapter 10 of the Assam Land and Revenue Regulation 1886 and are not found eligible to hold land in tribal belt and block. And secondly, paragraph 5, my lord, begs to state that the office of the district commissioner, respondent number 2 herein, has not initiated any process of rehabilitation as the possession of the petitioners are not found bona fide. Hence, the ejectment was carried out under section 165 of Assam Land and Revenue Regulation 86, and the petitioners cannot be allowed to occupy land in a tribal belt and block
The encroachers.
as they are encroaching.
Yes, what is the reply to this? You have filed a rejoinder. What is that stand?
My lord, before that, I want to point, my friend says, no hearing has been given to us.
No document has been, they asked to bring my document, no, nothing has been done, no.
Where's your rejoinder? Let us
And
see.
resident reply, my lord, I filed page 99,
Yes,
99,
yes.
paragraph 4, my lord.
Was there, did you give them a notice before evicting them?
No, no, this is not admitted. Then there
Notice not given.
Circle officer is,
Huh?
circle officer is.
Yes, Mr. Goswami. How did you, because you say the land records submitted by petitioner number 1 to 15 were verified.
Yes.
Now
By the
that
circle
means,
officer.
that means they have got they have been given an opportunity. Please see your records properly, whether they have been given an opportunity or not. Because in paragraph 4, you are clearly saying that the land records submitted by the petitioner number 1 to 15 were verified by the circle officer.
Yes.
Tribal will lordship.
That is the different thing, Mr. Goswami. You see, on merit, it is all right. They cannot stay in a tribal belt area in this fashion. That is all right. But if they, because they are claiming that they have been staying there for a long time, they've been paying their electricity and all that. Now, at least they are entitled for a right to hearing. Correct? They cannot be just thrown out. They can't be just thrown out, isn't it? So, please verify whether they have been given that right opportunity or not. Paragraph 4 somewhat indicates perhaps they have got it. Because otherwise, where did you get hold of these land records? You are saying the land records submitted by the petitioner numbers 1 to 15 were verified.
My lord, your lordship kindly see order
This
dated.
verification, where were these land records? You are saying it is submitted by the petitioner.
No. Your lordship kindly see order dated 4/1/4/10/2024.
Page
Passed by this honorable court. 4/10/2024. This honorable person or directly named the file affidavit 4/10/2024.
Yes.
Now lordship kindly page next page, paragraph 5 of that order. On or before next reasonable day, the respondent is directed to bring on record their stand by filing an affidavit. In addition to that, the respondent shall also indicate in the affidavit as to where this petitioner can be rehabilitated, taking into account that the petitioner have been already dispossessed from their land.
That
which
they are
then-
saying they
but
cannot.
nothing has been mentioned in their affidavit.
No,
We
that-
have
that-
stated in paragraph 5.
5 they have stated that the office of the district commissioner, the respondent number 2 herein has not initiated any process of rehabilitation as the possession are not found bona fide.
Yes.
That they have taken a call. Anyway, now since they are raising this ground that notice has not been given, suddenly the authorities came, demolished. Now, that may not be correct. All right, there is no doubt if they are illegal, but you follow the law. Law cannot be overruled, isn't
That's
it?
correct.
Only that part, you have a look. When?
2 weeks lordship.
What 2 weeks?
On 20 June.
Heard Mr. J. Ahmed, Learned Counsel, not right now. Heard Mr. J, because you see, Mr. Jayamit, they have to clarify that. If they show, if they are, if there is nothing to show that they have given you a notice, then of course, their action would be wrong. Perhaps since
Yes.
it's already demolished and you are illegal, maybe some compensation, I don't know.
All
You-
the 6 petition, not a single notice has been to everyone, madam, not a single notice.
You have to apprise this court that,
Whether notice was served.
and whether non-issuance of the notice, what will be the consequence?
But
The decisions are clear. You can't do it in
Yes.
that manner, isn't it?
Yes, ma'am.
Heard Mr. J. Ahmed, learned counsel for the petitioners. Also heard Mr. A. Bhattacharya, learned Bhattacharji, learned standing counsel, revenue disaster management, and Mr. N. Goswami, learned government counsel for the state respondents. The issue involved in these writ petitions is as regards the eviction and demolition of the demolishing of the petitioners' dwelling houses.
Dwelling houses.
Dwelling houses. It is the specific extent of the respondent number. This is respondent number. Respondent number 1 in the affidavit filed on 27 November 2024 that the petitioners have been, that after verification of the land records submitted by the petitioner numbers 1 to 15, it was petitioners, petitioners, it was found that none of the petitioners were in possession of valid land documents, and in fact, they are illegally occupying land which is in the tribal Belton block. Mr. Ahmed vehemently argues that without issuance of notice or giving an opportunity to the petitioners, they have been, their dwelling houses have been demolished and they have been evicted. The affidavit is silent as regards issuance of notice or giving opportunity to the petitioners. Mr. N. Goswami, learned counsel appearing for the state, shall clarify as whether opportunity or notice as required has been given to the petitioners before evicting stroke demolishing their dwelling houses. Relist on
20. 20.
20.
What?
20. ROA affidavit contumi koidibas. Affidavit filed in WPC number 5259/2024. And you see, Mr. Bhattacharya, you have said that this affidavit shall apply to all the other cases.
Yes.
But that means in all the other cases also you have a similar stand.
Yes.
Mr. Bhattacharya further submits that the affidavit in opposition filed in WPC number 5259/2004, which shall also be applicable in respect of all the other writ petitions being either number would be. These are, this whole branches from 32 to 36. And this affidavit is filed in 33.
Whether notice was served with them.
They may also bring the records.
Let the
Records
what
of the
record-
notice, all the records they bring.
Notice done, my friend.
No, there is very much necessary because we have.
All right,
participants-
you apprise first and then we will.
Lot.
All right. Yes.
Your lordship, the senior is on legs, your lordship. Kindly the matter may be passed over for the time being.
Affidavits have been filed.
Lot.
Will you be filing or not?
Lordship, on the same subject matter, SLP is pending before the Supreme Court, Lordship, and the next date of.
Any
yes-
stay order?
No, Lordship.
Then
And Lordship, the summary proposed notice has been issued by the state GST. I am appearing for central GST, Lordship.
who is appearing for the state GST?
My lord, I'm appearing on behalf of B2, my lord, 2, 3, and 4, my lord.
Are you going to file your return or not?
My lord, we are going to file our affidavit, my lord.
How much time?
After vacation, my lord.
Heard MS?
P. Sharma.
P. Sharma, learned counsel for the petitioner, also heard Mr.
H. Burwa, my lord.
H. Barwal, learned counsel appearing for respondent number
2, 3, and 4.
2, 3, and 4, and Mr.
K Jain.
A.
K Jain.
K. Jain.
Appearing for
Learned
5,
counsel appearing for respondent number
1, 5, and 6.
1, 5, and 6, not 1, I think.
Your
Appearance.
Your
Please give
lordship-
your appearances, huh?
Your lordship,
Mr.
there is an interim order, interim.
Miss Counsel, Mr. Barwa, so and so, seeks 2 weeks' time for filing return in the matter. Prayer is allowed to relist after 2 weeks on a date to be fixed by the registry. Interim, if any, shall be continued till the next date of hearing.
Oblige your lordship.
The next date of listing. Yes, Mr.
My apologies, my lord.
No, it's all right. Yes, Mr.
Yes, my lord.
Khatonia,
Yes, my lord. They have filed an affidavit and they have admitted the liability, my lord.
admitted liability.
Yes, my lord.
Yes, Mr. Neog.
This is with regard to the part payment, my lord. Part payment has been made, my lord. The remaining amount they have asked for. Works have been completed, my
No,
lord.
have you admitted that as regards the remaining?
Right.
How much more time?
My lord, 2 months, within 2 months.
So I'll dispose it off.
Yes, ma'am. My lord can dispose it.
Right.
Yeah, yes, my lord.
You write Nyog or Nyogi?
Nyogi, my lord,
Nyogi.
with I.
This is from 62,
60 to 66 and one more actually.
60 to 66.
Yes, my
60
lord.
to 66 and one more is there, my lord.
Just give me the item number.
Yes, my lord. So. 8 আছে total.
Your affidavit is there in each cases.
Yes, my 60 up to 67, my lord.
67.
Up to 67.
So 67 is here only.
Yes, my lord.
Yes.
It is 60 plus 67.
67.
Huh? Mr. Neogi, your affidavit is there in each cases.
Yes, my lord.
So the amount must be different. In
Different
each
amount, my lord, and the name of the construction committee as well as the works. Amount, work, and my lord.
Where in the first, I am holding right now 6489.
In 6489, my lord.
Can you just point out in which paragraph of that affidavit in opposition I get these amounts? Is it paragraph 9?
Paragraph 9, my lord. Starting from 6th line from the bottom.
However,
In respect of the present petition.
Not getting that. In the
Next
same
page.
paragraph.
My lord, page number 2.
Oh, it's the next page.
Yes, ma'am.
1 second. In respect of the present petition.
Yes, ma'am.
The student, the female petition has also been verified and inspected by the EQ. So, PWG. Said what? Now, but how much is due? Where do I get that?
My lord, my lord will get it on page number 11, my lord, of the writ petition.
Page 11. Yes,
Here, my lord, in this work, my lord, the total amount is 5 lakhs.
yes,
Out of 5 lakhs, first installment of 3 lakhs has been released, my lord.
yes.
So remaining is 2 lakhs, my lord.
That remaining is not here, but otherwise,
Yes, my lord, remaining, my lord, will find.
so
The bill-
without specifying the amount, it can be
My
just.
lord can dispose
Yes,
of,
yes,
my
my
lord.
lord.
Yes,
Because,
while my lord can specify the name of the construction committee as well as my lord the construction work. And
And that is different for all.
yes, my lord.
Where do I get those names?
My lord will get
all in the annexer A, my lord.
The
annexure A, my lord, my
Annexure
my lord will get. Name of the scheme, my lord, construction of.
All right,
Yes,
all
ma'am.
right. That is the scheme. And then
Then
constituency is also different.
Yes, my lord.
Yes, my
also-
lord.
Also different.
some.
Then, my lord-
एक ही हो पाए.
I
amount.
think, Mr. Khatuniar, you might have to just, in a piece
I'll-
of paper,
Yes, my lord.
you
I'll-
just give it to my,
Yes, my lord.
otherwise, you
will be
will
better.
be at the receiving end.
Yes, yes, my lord. Yes, my lord.
For me,
Absolutely.
I can just dispose it in 1 minute. At the end of the day,
Yes, ma'am.
you have to receive all this.
Yes, my lord. I'll discuss.
So let me just start with the first one and then we'll see. Okay, but
Yes.
you, in the meantime, you can ask one of your junior to
Yes.
just prepare that. Like Hassan. Heard Mr. N. J. Khatonia, learned counsel for the petitioner. Also heard Mr. S. Yogi, learned standing counsel, Tiwa Autonomous Council for the respondent authority. Huh? By way of this petition under Article 226 of the Constitution of India, the writ petitioner is seeking release of the funds due to the petitioner for completing the work of council for construction of Sonkori Christi Chora at Padumpukuri, Bhagwa, allotted to the construction committee headed by him. Vide order dated 26/2/2018. তুমি বাকী গোটা কেছত এই বস্তুটো প্ৰেয়াৰত পাবা। So just check the prayer, তেওঁলোকে দি দিব পাৰে, but cross check with the prayer. Huh? This is hereinafter referred to as the subject construction work. Anna? The brief facts of the case is that the petitioner, being the president of the construction committee set up by the Tiwa Autonomous Council for the purpose of undertaking and completing construction projects, was allotted the subject work, and the value of the said work was rupees 5 lakhs. Out of, it is the specific case of the petitioner that out of the total sanction amount of rupees 5 lakhs, an amount of rupees 3 lakhs was released as first installment. However, due to non-release of the balance amount, the present writ petition has been filed. Heard, perused. Huh? It appears that the petitioner, pursuant to the issuance of the subject work order, started the construction work allotted to him and after duly completing the same within the stipulated time, submitted final bill for release of the final installment accompanied by utilization certificates, photographs of the work, as well as with the inspection report of the concerned junior engineer. It appears that the petitioner is entitled to receive the balance payment due to him for completion of the said work. Accordingly, it appears that accordingly. It further appears from the affidavit in opposition filed on behalf of the respondent number 2 that the claims of the petitioner has been verified and inspected by the APO Technical Tiwa Autonomous Council, Morigao, Assam, and also by Executive Engineer PWD Morigao District Territorial Building Division, and has been found that the petitioner has successfully completed the said work. Apt to reproduce paragraph 9, na?
9, my lord.
Paragraph 9 of the aforesaid affidavit in opposition for ready reference, quote unquote. Etufaba, page 21 not. The aforesaid balance of the remaining bill being admitted at this stage, I will say your submission. At this stage, Mr. S. Nyogi, Learned Standing Counsel, Tiwa Autonomous Council, in his usual fairness, submits upon instruction that the balance admitted dues of the petitioner shall be released within the period of
2 months.
2 months from the date of receipt of certified copy of the order. That being so, this court is of the unhesitant view that this petition can be disposed of with direction to the respondent authorities to release the balance admitted amount to the petitioner company, na?
Just committee.
Petitioner Construction Committee within a period of 2 months or 3 months?
3 months will be better.
3 months from the date of receipt of the certified copy of the order in accordance with law. Disposed of. I think the work order to be paragraph at Pajaba for all the other cases. The amount perhaps you might just have to indicate.
I've already prepared a list.
You prepared a list?
I'll hand over.
So
Right,
66 to 67, huh? All right. None appears for the petitioner on call. List relay MS and Borderloy, Learned Standing Council, Revenue and Disaster Management is present. Relist on Friday with remark for dismissal in the order column.
Legend.
None appears. None appears for the petitioner despite the matter being called twice.
Let me come to page 20.
Yes, Mr. Bakshi, you are a legal aid counsel and you were not here when the matter was called in the first round.
I was stuck in the public. There was water logging.
Yes, Mr. Goswami.
Let me come to
Affidavit.
Yes, till now they have not filed one.
Well, let's see the last order, let's see 2-1-20. And what is it?
Petitioner was seeking.
Yes, you were supposed to obtain some instructions.
Yes, ma'am. The instruction is regarding, I have purchased a plot of land and NRL has started construction, illegal construction in the plot of land. Now I've also applied for patta. My lord may kindly see annexure in the petition itself. My prayer is dual prayer. One is for granting me patta and second is to restrain the NRL from illegal construction and pay me compensation.
Your sale deed is unregistered.
But the respondent authority.
What is your right? What's the legal right?
Yes, my lordship may kindly see annexure 6, page 32, my lord.
Huh?
Page 32, annexure 6. In the
Why
year.
didn't you file your objections,
Yes,
Mr. Goswami?
Lordship.
File your objection.
And the respondent authorities are also
Because I
inspection.
any amendment has been filed.
Lordship, can you see the page 37?
37.
This is under challenge, my lord.
Where are three, Lordship?
This is, I am not aware of.
At the time of spot verification, it is seen that there is no connection of the plot of land mentioned by the applicant documents.
Where?
Page 37, my lord.
Page 37.
This is absolutely false report, my lord.
Please read paragraph.
Three. At the time of spot investigation, it is seen that there is no connection of the plot of
Mr.
land.
Bakshi, is this a writ petition or not?
Yes.
Yes, ma'am.
How this court is going to enter into this disputed question? It may be false. How is this court going to enter into all this?
He annexed this application.
My lord, thereafter,
Huh?
my lord, may,
And
my lord, may kindly see, thereafter also I have pursued, my lord, that is
Mr. Bakshi, are you
8-7.
appreciating what the question that is coming up from the court?
Because they themselves have dual versions. Someone is saying, give me,
So that means there is a disputed question of facts.
or she may kindly see.
Mr. Bakshi, please enlighten this court as how a writ code under Article 226 of the Constitution of India can enter into the disputed question of facts.
Because this
Please
is not
entitle,
disputed.
please
This is false.
enlighten
My
this
contention
court.
is this is false. No witness have been examined. In fact,
Mr.
I was
Bakshi, when you're saying false,
yes, my lord,
what does that indicate? That there is a dispute.
because the government respondent authorities illegally prepared this report, my lord. Let them file.
List on any other date.
Let them file.
Mr. Bakshi, you please rethink what the court has asked.
Yes, my lord.
List on any other date. Yes, next.
Yes, they are not entitled for that.
None appears for the petitioner on call. Heard Mr. S.S. Roy, learned State Counsel, and M.S.N. Bodler, learned Standing Counsel, Revenue so and so. Mr. Roy submits that the petitioner is not entitled
For the compensation.
for the compensation as prayed for. Be that as it may, since the petitioner has not, that there is no representation on behalf of the petitioner, despite the writ petition being called twice today, list again on Friday in the order column with the remark for dismissal. This is also same?
Same law.
Same order, huh? This is also, I think, same? 12? Same, right?
Yes.
Same names. I think Bhattacharjee is there.
Yes.
In 12, otherwise same, but you give Bhattacharjee's name for revenue with Mr. Roy. Yes.
Item number 15.
None appears for the petitioner on call. Anybody for the respondent in this matter? Despite the matter being called twice, relist on Friday in the order column with the remark for dismissal.
Item 15.
My lord, I am appearing on behalf of S. Hawk, Youngest Counsel.
Yes.
He is out of station, my lord.
All right.
May-
Mr. Since there was no representation on the matter being called initially, the matter after being called on the second time, Mr. A.
Rahman.
Raman informs the court that Mr.
S. Hawk.
S. Hawk, MD S. Hawk, Learned Counsel appearing for the petitioner is out of station, and accordingly seeks posting of the writ petition after
2 weeks.
After 2 weeks, as per his request. List after 2 weeks and a date to be fixed by the registry.
Oblige, your lord.
Then appears for the petitioner on call despite the matter being called twice. MS, you're there?
Yes.
MSN Borderline, Standing Counsel, Revenue so and so, relist on Friday in the order column with the remark for dismissal. Yes, Mr. Cholia?
Lordship, in item number 22, Lordship, I am seeking 10 days accommodation, Lordship, because the petitioners can no longer, the counsel for the petitioners, they can no longer appear in the matter, Lordship.
Heard Mr. A. Chalia, learned counsel appearing for the petitioner.
Lordship.
And Mr. You there?
Yes.
Mr. A. Bhattacharjee, learned standing counsel, revenue and disaster management. Mr. Pacholia seeks
10 days time.
10 days time. As prayed for by Mr. So-and-so, relist after 2 weeks on a date to be fixed by the registry. You do what is to be done in the meantime. Yes.
GMC is supposed to file affidavit, my lord, last occasion.
Where is GMC? GMC, Mr. Cholia is there. GMC. I think one of your colleague, Mr. Cholia, would be there in GMC. All right. GMC Ahile Matidua, just be in court because I think it is better to ask them if they are interested or not to file. Otherwise, we will go ahead. Yes, Ms. Chaudhary.
You apologies for not.
No problem, Ms. Chaudhary.
My lord, these are all catering contractors, both Jayanta Kumar Ghosh and Rajendra Kumar.
Catering
Magda.
contractors mean railway or what?
Yes, lordship. And
Similar.
lordship, they are running tea stalls in Guwahati and Kamakya, the petitioner number 1. The second petitioner also is running tea stalls.
Affidavits filed or not filed? Mr. Gupta, you are for the.
Lordship, there is an issue in this.
Affidavits have been filed, my lord. But these matters are covered, my lord. I am placing reliance on.
Yes, what
Lordship,
is
there
the
is an issue
order?
in this.
One sec, Mr. Gupta, let Ms. Chaudhary first complete what she was saying. Yes.
Here the issue was whether the petitioners can take the, they were all catering contractors and they were in fact ordered to vacate the tea stalls.
Vacate the
tea stalls.
Tea stall.
That they were running. So challenging those vacation order, they had approached this honorable court. First, this petitioner number 1, Jayanta Kumar Ghosh had come and he was given interim protection by this court, single judge. Then again, Rajendra Kumar Mangla had also come. He was also given interim protection. Thereafter, my lord, another similarly situated petitioner, namely Deepak and Company, running a partnership firm, was before this court. But his case did not find favor from this honorable court, neither from the single judge nor from the honorable division bench, and he had also preferred an SLP that was also dismissed for when the counsel could not appear due to some circumventing reasons. That was dismissed finally. Now the case is, and these 2 petitioners, however, are protected by the single judge of this honorable court. They are given interim protection. Now again, another similarly situated petitioner was there, namely the NF Railway Vending and Catering Contractors Association. They were also aggrieved by the order. They had approached the Honorable Supreme Court and their case has, in their case, there is an interim protection in that in the members of the petitioner association shall not be dislodged from the spaces under their occupation. And accordingly, they are now carrying out their businesses.
In these cases, the interim orders are there or not there?
Yes, it
It's
is
already there.
Yes,
But today it has come for what? For admission.
yes, Lord. And
Mr. Gupta, these matters can be admitted.
My lord, in fact, similar matters has already been disposed. I have given lordship orders by the single judge. Thereafter, my lord, it was challenged before the division bench. And then, my lord, it was.
Which one? This one?
Yes,
Deepak and
three
Company.
orders I have given, my lord. The first is the single bench order, my lord, which was carried forward to division bench and it was affirmed.
One second. The single judge judgment is to what effect?
That, my lord, that
Petition-
there is
the
no.
petition
there
has
is-
been dismissed.
Yes, dismissed. No, there is no scope for renewal under the new catering policy.
Does not provide for renewal. Here also they are seeking
Seeking
renewal.
renewal. And my lord, in
This
petition
is-
number,
Petitioners cannot have any legitimate right. Now, this order was taken.
To the division bench.
division bench WA one
Yes,
twenty-four
it is dismissed.
dismissed. And then it was taken to challenge, my lord.
No, but what was the undertaking? However, considering the submission made by the petitioner, we are inclined to grant time for handing over the vacant possession to
Yes.
so and so, subject to an undertaking to be given stating that the petitioner will vacate the premises on a so and so.
Now thereafter, he
The
has been.
undertaking is to be filed, especially with the yes, so that means this is now holding the field.
Field. And my lord, in item number 26, if my lord will take page number 23, the notices, the impugned notice was issued to Deepak and Company, which has attained finality. And
So the single judge first went into appeal. Writ appeal.
my lord,
Writ appeal also dismissed.
dismissed,
And then appellate court
SLP.
SLP also
also
dismissed.
dismissed.
Yes.
And if my lord will take, my lord, in item number 26, page 23,
26 to
for a moment, my lord, same petitioner,
26 are filed to serve. But Ms. Chaudhary, then you are covered by these judgments. This
My
court
lord-
now cannot hold otherwise. Apex court
That
has
also
also
covers, my lord,
Huh?
the case of that NF Railway vending and catering contractor.
but that is
that order was, my lord, prior. And the order which I have given, my lord, is of 2510.
you see this order which you are giving is only an interim order.
Yes, and that is of.
Correct.
August,
then
that date,
thereafter,
my lord,
my
will
lord.
just peruse the date.
Wait, I cannot hear when both of
No.
you will say.
I'm sorry.
No problem. Yes, Ms. Chaudhary, thereafter.
Thereafter, again, an order was given that till the next returnable dates, the steps were
That's all
directed.
right. But ultimately the apex court has
That is of 13.
Not
Eight
mine
such.
case, my lord, it was another similarly situated, and they were partnership firm.
all right, then I'm admitting it and or otherwise I'm posting it another date.
My lord can dispose all the, my lord, what I was pointing out, my lord, page 23 in item 26. My lord will see this notice was under challenge, my lord.
26.
Page 23, my lord.
Yes.
My lord will see the persons to whom the notice was addressed. This was the impugned notice. One is, my lord, Deepak and Company. And my lord, the second is Ravindra Kumar R. Mangla. So far as Deepak is concerned, my lord, that has attained finality. He has evicted the shop. He has been evicted from the shop. And Ravindra R. Mangla is, my lord, in item number 26. Same person. And this was the impugned notice, which is now, my lord, under challenge in item 26.
Deepak is this one, na?
Yes, that has attained finality. He has been evicted from the shop also. And thereafter, many shops, my lord, railway stalls have been vacated in terms of these orders. Only these three petitioners are, my lord, continuing since on the strength of the interim order.
My lord, and
So attained finality, my lord. Ravindra R. Mangla is in item 26 and same order is impugned. So far as item 26 is concerned, my lord, it will be covered.
This has been continued again. That interim order has been continued. This one.
Yes, my lord.
This is date is. Where do I get the date? 6/11/2024.
Yes, my lord. Thereafter, the
The-
matter has not been listed.
Not listed.
Yes, sir.
But that order is of, my lord, August 24, and the order is of
And
25/10.
So one which you had just given is of when?
25/10, my lord. So that has attained, my lord, culminated into, that has attained finality because it's a subsequent order. Same issue.
Ms. Chaudhary, the difficulty is that on 25/10/2024, the apex court in a similar situated facts have clearly held that we do not find any ground to interfere with the impugned orders passed by the High Court.
Lordship, but
And the effect of those orders is is dismissing the writ petitions for renewal, which is the prayer in this writ petition as well, correct?
lordship.
So,
And it was also the prayer in that case, lordship.
Ms. Chaudhary, you have to appreciate
Yes,
that
Lord.
there interim, it is only interim order and prior to this apex court finally hearing and dismissing a matter. Now, the order of October 20, this order is October,
11/3/24 order.
huh?
My lord, 11/3/24 order by the division bench, my lord, in WA 124,
11/3/24.
24.
And the apex court is 25/10/24.
My lord. That writ appeal order has been affirmed. And on
The apex court, and before the apex court, this order perhaps is also not shown.
not shown, not shown. Not shown.
You understand what I'm saying?
Yes, my lord.
So I
they
am faced with a situation where there is a final order of the apex court and there is an interim order of the apex court. Now you tell me which one am I bound to follow? The final order of the apex court or the interim order of the apex?
The thing is this.
It's a very,
Contractors, lordship. And
that is all, Ms. Chaudhary, what is
Yes,
to be
sir.
done. You have to take it there. Because it is already, once the division bench have dismissed the writ petition and the apex court has upheld it, nothing to be done here. Unless, of course, tomorrow again for some reason a larger bench interferes, then perhaps situation may be different, but that is not the situation today. You take your instruction, otherwise I'll have to dismiss it. At this stage, I cannot
Yes, lord.
do anything.
Because many shops, my lord, thereafter they have been vacated. Now these three petitions are remaining, so it is creating an
I can have this matter posted on Friday. You take your instruction.
inequality also because those petitioners.
Because otherwise I'm dismissing it right now.
Can it be next Monday, lordship?
Monday. Mr. Gupta, Monday,
My lord,
you obtain your instruction because you can dismiss with liberty if you, withdraw with liberty because otherwise there is no point. And if you want this court to do it, this court will do it on Monday.
Tuesday, lordship. I have some personal.
All right, Tuesday. It appears that the issue involved in this writ petition has already been decided by this court in WPC 1828 of 2023 in the case of Messrs. Deepak and Company and others versus Union of India, which has been upheld by the division bench of this court in WA number 124 of 2023 in Messrs. Deepak and Co. versus Union of India, and which has been also upheld by the apex court in SLP number, which is the number, Mr. Gupta?
17, my lord, 338.
1738 of 2024. in by judgment in order dated 25/10/2024 in the case of Deepak and Company versus Union of India. MSB Chaudhary seeks a short accommodation to obtain instruction in the matter. List again on Tuesday. You see, because this
Yes,
final, there's nothing much to be done. You take your instruction, otherwise we'll dismiss it.
Till then, the interim is. Much.
Lordship, I'm sorry, I should not appear. Lordship, in this matter, my grievance is limited to the fact that the respondent authorities have constructed a highway over my plot of land without following the process of law as under the National Highway Act or for the matter of fact under Article 300A. To
Mr.
substantiate,
Gupta is there or he has left? Can you ask Mr. Gupta? Ms. Chaudhary, just be there. Yes?
yes, Miss, I am saying that the respondent authorities have constructed a highway over my periodic patta plot of land.
Item number 31.
Item 31.
Yeah.
Without following the procedure as laid down under the National Highways Act 1956.
Sorry.
No, it's okay, Lord. Without following the procedures under the 1956 Act of National Highways Act and Article 300A of the Constitution of India. So to substantiate that, Lordship, I'll have to take your Lordship through the records and the annexures of the writ petition.
This matter is ready for hearing.
The affidavit has been filed by the standing. I have filed my reply also.
Case is ready. It is posted for hearing in the month of August.
Yes, Lordship. Your date may be fixed then, Lordship.
Fixing date for hearing might be difficult in the month of August on any date.
Yes,
She will give you a heard Mr.
MP Chaudhary.
MP Chaudhary. MP Chaudhary, learned counsel for the petitioner, also heard Mr. J. Shutia, learned you're appearing as the standing counsel. Standing counsel for KAC. Learned standing counsel KAC and Mr. R.K. Talukdar, standing counsel NHIDCL, and Mr. Bhattacharjee, A. Bhattacharjee, learned standing counsel, Revenue Department, Revenue and Disaster Management.
Yes.
So and so. Anybody else? I think government is also there.
Government.
Yes, Mr. Are you for government? Mr. K.K. Bhattacharjee, learned government advocate for the state respondent number 8. The matter requires full-fledged hearing. Admit no formal notice as parties are represented. List for hearing in the month of August on a date to be fixed by the registry. Mr. Goswami, I think this is this matter pertains to government advocate. I have recorded Mr. K.K. Bhattacharjee's name, but I think it is bench. Just check, because if it is your name that has to come, then she will make the change. Just find out.
Our name is not been shown.
Anyway, I'm just recording it. I have since you were not there, I've recorded Mr. Bhattacharjee.
In the cause list also our name.
Lordship, for hearing in the month of August. Highly obliged.
Mr. Gupta, you see, I have not said about the interim order to be continued, but that doesn't mean that they are disturbed. Because the matter is posted on Tuesday.
We are not doing
So
doing it.
please,
Since 1.5.
not to disturb.
No, my lord.
Otherwise, I'm direct.
No, my lord.
I'm making it very clear.
Since last 1.5 year, we are not doing
That
it.
is why. Otherwise, I'll say that till Tuesday.
No, my lord, we will not do it.
Otherwise, I'll make that order till Tuesday. Let it be
My lord can continue it.
till Tuesday in the earlier cases. That item number?
25, 26 and 27.
Just record that the interim order passed earlier shall continue till give that Tuesday's date. Because it doesn't look good, you see. They are on an interim, and since it's on Tuesday. Ms. Chaudhary has left, or what? You inform her?
Here I have received my instruction, but not adequate to find an affidavit, my lord.
I have received my instruction, but not yet required to file an affidavit, my lord. I think
You want
some
to file an affidavit?
Sorry.
Heard, Mr.
MJ
So and so learned counsel for the petitioner also heard Mr. S. Bora,
Bora for
learned standing counsel.
GMC.
GMC. Mr. So and so submits that though he has received the instructions, however, he wishes to place the same by way of an affidavit in opposition. Prayer is allowed, relist after 3 weeks on a date to be fixed by the registry to enable the GMC to file their return in the matter. This is an RSA, Mr.
Yes, yes, I have
Dasgupta.
formulated a substantial question, right?
Huh?
I have formulated a question, right?
Let me connect to CPC now. I was dealing with writ for the last 2 hours. So today is for framing substantial question of law.
Well, this is.
Yes.
This is the dispute between two brothers. Elder brother issued a civil suit against his brother.
You have 2 concurrent findings against you.
No. Reversal content.
Reversal.
Reversal.
So you are the plaintiff.
No, I was the defendant.
You are the defendant. But initially the suit was in favor of the.
No, initially suit was decreed, partially decreed.
That was taken into appeal. Reversed.
Reversed.
And what was the suit for?
Suit for the declaration of right title interest and eviction.
And the dispute is between brothers, you said.
Two brothers. Now, elder brother's case is that I have allowed you to stay here, but I asked you to vacate the land and I served a notice to you, but you have not vacated it, and thereafter he has instituted this. Now, 2 notices were served, Exhibit 9 and Exhibit 10. So far, Exhibit 9 is concerned, it is stated that you have trespassed my land in the year 1975-76, and this notice was issued in the year 2005. And so far, the next notice is concerned, it is stated that earlier notice there is a mistake. Instead of 1975, it should be 1995.
Where are the questions?
Well, I have formulated the question, brother.
Oh, it has, this has come for the first time.
Again.
For the first time.
First time. I have improvised it, not to some extent, in a smaller way. Though these are same, but yes.
What is substantial about this? These are all factual. These are all factual questions.
No, what happened here.
The admission, whether it amounts to, whether the admission of the received amounts to admission of the contents of the notice.
That is not factual. That is
one of the court has already taken a perception. Based on it's a perception. Now this court, just because this either you or this court doesn't agree, the matter doesn't become a matter of substance. The question.
I do not follow your story.
I
do not follow your logic.
You see, if a particular in perception of the appellate court has taken a perception as regards the admission of the receipt.
No,
just because another view is possible doesn't mean that that question has of any substance, isn't it?
Yes.
At the end of the day, it is a substantial question of law which has to be existing. So,
So what happened in this case, my lord? Case is very simple. Elder brother's case is that I have allowed you to stay in my land, but you have trespassed my land, and that is why I issued a notice to vacate this land. That notice was issued sometime in the year 1975. And where it is stated that you trespassed my land in the year that notice was issued sometime in the year 2005. Where it is stated that you have trespassed my land in the year 1970.
it's gone. Yes. I don't know about that side, but I'm freezing here.
Yes, sir, I am also freezing.
Huh?
I am also.
Why nobody said anything? Yes.
The notice which was issued in the year 2005, that is Exhibit 9, it was stated that you have trespassed my land in the year 1975. Subsequently, Miller, another notice was issued some few days after, where it is stated, it should not be 75, it should be 1995. Reason is that its suit was instituted in the 2006. So if we go by 75, then there is no cause of action. And subsequently, if it goes by 1995, then he has a cause of action. That is one of the points. Now, my case is that, so far your notice is concerned, I have received your notice, but that is not my case. It is our fraternal property. Though the land was purchased in your name, but this value of the land.
This matter will have to be heard in some length because we cannot just formulate these questions in this manner. Prima facie, I have reservation. So have it on another date. We'll have to go into the details. We'll have to look into both the trial court.
Yes, your lordship may can issue notice. In the meantime, a portion of the degree of the maybe can be stated. Execution.
We're not doing that. We are immediately hearing it.
Proceeding has been instituted.
There you can apply. Today is Wednesday, huh? Monday. Relist on Monday.
The only problem is that the execution.
All right.
Execution proceeding has been issued. It's all case of reversal.
Monday.
So I may be permitted to add some additional grounds, of course.
Yes, you take this back. You look into it because prima facie, I'm not with you today. That's why I have given you time. So I'm not saying anything. To grade you.
All right, let it be there.
This is an order matter.
Lordship, appeal number 2 and 3 has died, Lordship. Appeal number 2 and 3 has died.
So setting aside abatement is also there. Substitution. And there has been delay.
Yes, your lordship. We have filed an affidavit, your lordship.
You have filed your objection?
Yes, your lordship.
The delay?
Yes, your lordship.
What is your objection?
Your lordship, the appellant has engaged new state advocate, which has been explained, but regarding the engaging advocate in the they have engaged the advocate in the month of in 2018, but the appellant could not explain that they have taken 6 months period after engaging the advocate to filing this delay petition, your lordship. Regarding
Mr. Goswami,
Lordship, the appeal.
No, where are the grounds?
Lordship, can we see the earlier advocate has
just let us see the grounds first. You must have made the where do I get the grounds?
Para 3, Lordship.
Para 3.
Lordship. May I read? Or
yes, please.
Appellant begs to state that applicant number 1 has taken all steps in connection to the aforesaid case. Appellant number 1 has engaged the present new set of advocate to conduct the aforesaid case in the month of September 2018. Thereafter, appellant number 1 came to Guwahati on 17/3/19 to discuss about the case with his new set of advocate, and during discussion it has came to knowledge of the learned counsel that the appellant number 2 Uday Sharma died on 2/11/2016. But applicant number 1 could not inform the earliest set of advocates about the date of applicant number 2, Uday Sharma, at the earliest set of advocate of the applicant, also not ask the applicant number about the status of the parties. Applicant number 1 is not aware about the necessity of procedure to file application for substitution of the name of legal heirs in case of death of any of the parties in civil cases. Immediately on 18/3/19, applicant number 1 handed over the particulars of the legal heirs of the representative and deceased applicant number 2 to his learned advocate. Accordingly, application for substitution along with the application for setting aside abatement for condonation of delay has been filed on 19/3/2019. Therefore, there is a delay of 776 days in filing application for substitution of legal heirs and representative of deceased applicant number 2, Uday Sharma. In this particular case, Lordship will aware that.
But Mr. Goswami, September 18, you have you have engaged a counsel.
Lordship.
Then you come to Guwahati on March 2019.
Yes, sir. Lordship, 17.
Discuss about the case with his new set of advocates. And during the discussion, it has come to the knowledge that the so-and-so died on so-and-so. But the applicant number 1 could not inform the earlier sets of advocate about the death. I mean, it is not very clear. What are you trying to say here? I'm sorry, I have not understood.
Lordship will kindly
When you meant that you had engaged a counsel in September 2018, are you referring to the present counsel or the earlier counsel?
Earlier set of counsel.
So after, then what prompted you to appoint a new set of advocates? Where are those explanations?
Lordship, earlier BK Goswami was there in this.
Where are the explanations?
That has not been given in this.
Then, you see, this is
only thing is,
Mr. Goswami, please appreciate that you are before a condonation court right now. It is discretionary, but you must make out a sufficient case because the grounds that you will urge, this court will have to exercise its discretion and apply its mind and to see whether the grounds are sufficient or not. Correct? I am not asking for one day explanation here, but overall that explanation has to come. From 18, you jump to March 19, and the in between, what happened, new set, what happened, nothing is said. If required, you file an additional affidavit.
I can file an additional affidavit.
Everything.
Lordship, I can.
Because unless the explanation is there, he is right.
Understand, Lordship. Only thing is, Lordship, kindly consider one thing. I'm also agree with him regarding these statements made in the petition. But only thing is, Lordship, there are not really one appellant.
Huh?
Not only one appellant. Appeal has been preferred by altogether 4 appellants. Out of these, 2 appellant has died. Without substitution also, this appeal will exist. No harm will cause to them.
That is a different thing.
No harm will cause to them. Appeal will be hard on merit because other appellants are still alive and they are contesting the case.
No, you file an additional affidavit.
I will file an application.
You want to explain, you explain.
I will file an additional affidavit.
I will find them.
I will file an additional affidavit to that effect regarding disclosing.
You file it.
I will file an additional
as prayed for by Mr. S.K. Goswami, learned counsel for the applicant, released after
1 week.
1 week on a date to be fixed by the registry to enable the applicant to file an additional affidavit to explain in details the grounds for grounds of delay.
Obliged.
My lord, here service is completed, my lord. I am for the response number 7. I have filed my affidavit in opposition also, my lord.
You want to file?
I have already filed. It is flag A, my lord, my affidavit in opposition. I am for the response number 7.
Okay, this matter has been, then it can be listed for admission?
Yes, my lord. Service is complete, my lord.
Heard, Mr.
ZH Bora. On behalf of Mr. S. Borthakur.
40, this is item number?
42, my lord.
42. Your name is Mr.
ZH Bora. ZH Bora. Bora.
ZH Bora. Learned counsel appearing on behalf of Mr. S. Borthakur, learned counsel for the petitioner. Also heard Mr.
S. Hazarika, my lord.
S. Hazarika, learned counsel appearing for respondent number 2. Mr.
7, my lord, 7.
Huh?
Respondent number 7.
And respondent and Mr. N. Goswami, learned counsel appearing for respondent number 1 to 5. Now, what about 6 and 8?
It was, my lord, I think 6 is Dusty affidavit has been taken, my lord, and 8 is deemed served, my lord. As per Lozima, there is Lozima court order, my lord.
But 6 and 23, my lord, Lozima court report, my lord.
It appears that the notice in respect of respondent number
So, but 6 is Lozima code report is 1023 madam.
comma, the office note dated 7/1/2025. No.
Yes, madam.
No.
So, for the respondent number 8 is concerned, it is
Six is which date?
6/10/23 madam.
Huh?
6/10/23. Six to is it? Names are rows. That's the.
I see all. Something is confusing here. It only talks about 8. What about 6? You have filed a dusty.
Yes, madam. 6 madam in Lozima it says by deemed to be served, madam.
Where? Which one?
Can I, madam?
HE2 comma visa. Miss Chaudhary, in that matter of yours, I've already extended the stay till Tuesday.
Fourth paragraph, fourth and fifth paragraph.
Office note dated 6/10/2023 indicates that service in respect of respondent number 6 stands complete. However, in respect of respondent number 8, the office note dated 7/1/2025 indicates that in respect of the notice issued through dusty mode, it appears that since the petitioner, since the respondent number 8 was not available at his house, the dusty notice could not be served.
Yes.
And in respect of the notice issued through the registered post with AD, it appears that the notice has been delivered to the addressee on 22/3/2024. And in respect of the notice issued through usual court process, the notice has been received by the respondent number 8's daughter-in-law in his absence. As such, the service in respect of respondent number 8 also stands completed. Correct?
Yes.
Now, we can post it for admission. List this matter for admission in the month of July on any date to be fixed by the registry.
I'm deeply aware.
Yeah.
Notice note. Order dated 27/5/25 lordship. Notice was not served.
Not served.
No.
Await service in respect of respondents. List after 3 weeks on a date to be fixed by the registry.
We issued notice lordship. This is long pending.
All right, next.
Hello.
None appears for the petitioner on call. Yes.
Lordship, I am appearing on behalf of Mr. S.P. Chaudhary. Lordship.
Yes. What about your affidavit? Are you planning to file?
Lordship, we have received one speaking order in compliance with the order, impugn order dated.
Why are you not filing it by way of an affidavit? Time and again, this court has been emphasizing filing of affidavits in contempt matters.
Lordship.
This court is not going to take papers across the bench like this, in this fashion. These are not ordinary litigations.
Yes, Lordship.
These are contempt
Kindly-
petitions.
Kindly 1 week time may be granted.
MS, your name?
B. Devi, Lordship.
B.
B. Devi.
B. Devi, learned counsel appearing on behalf of Mr. S.P. Chaudhary, learned counsel appearing for the sole contender, submits that she has received instructions in the matter and seeks a week time to place the same by way of an affidavit.
Yes, sir.
Prayer is allowed. List after a week on a date to be fixed by the registry.
Deeply obliged.
May I plead the Lordship?
Yes.
I'm appealing for the appellant. Lordship, the service has been completed, but today it has come to knowledge that the service has been completed, Your Lordship, but it has come to knowledge today that performance response number 2 has expired.
Oh.
So, Your Lordship, may Your Lordship grant us some time to avail the details.
Your
of the
name?
detail here.
Your name?
N. Bhuya on behalf of R.K. Bhuya.
Mr. N. Bhuya, learned counsel appearing on behalf of Mr. R.K. Bhuya, learned counsel for the appellant. Stop. Mr. Bhuya submits that it has come to their knowledge that pro forma respondent
number 2, Your Lordship.
2 has expired in the meantime and
Yes, sir.
accordingly seeks a short accommodation to do the needful in this regard. Prayer is allowed. It further appears that the case records has already been received and the office note dated 26/5/2023 indicates that service in respect of respondent number 1 and 3 has also been
Completed, Your Honor.
completed. List after 2 weeks on a date to be fixed, 3 weeks on a date to be fixed by the registry.
Oblige, Your Lordship.
Yes, Mr. Majumdar.
Lordship, as per office note dated 28/5/2025, Lordship. Service is the respondent, Lordship.
Service is completed.
Completed, Lordship. Appeal has been admitted, LCR received, it may come up for usual course for hearing, Lordship.
But today is for orders.
So is order for Lordship, the necessary order regarding service of other respondent.
It heard Mr. K.K. Majumdar,
Lordship.
learned counsel for the petitioner, also heard Mr. P.S. Deka.
J.H. Loskar.
J.S. Lockor, learned counsel appearing for
Respondent number 9.
respondent number 9. It appears that the second appeal, it appears that service in respect of the remaining respondents, i.e. respondent number 1,
1, 2.
1 within bracket Roman 1, 2, 1 within bracket Roman 4, comma 2 to 5. You are for
respondent number 9 here.
6 and 7 has been completed. Only 9 respondents.
Only 9 here. We are only 9.
Is perform.
Proforma respondent.
Huh?
Proforma respondent.
Who is pro forma?
We are proforma defendant.
No, but otherwise that means all respondents have been served or not?
Already served as per official shows, Lordship. 28/5/2025, Lordship. Order office note, Lordship.
What was the last thing you said? Remaining respondent service is completed, I've said, na? So it's completed. It further appears that the case records received.
Received, Lordship, as per office note shows, Lordship.
That the case records has also been in the meantime received from the from both the trial court as well as the first appellate court. List for hearing in the usual course.
Much obliged, Lordship.
May I please, Your Lordship?
Yes.
It's an contempt matter, Your Lordship. The respondents were directed to pay a sum of around 7,50,000.
Yes, but what happened? Service
Office
AD
note
card.
27/9
Await
27/5.
await AD card. Await service.
Lordship, but what happened in this case? The contender they are by name, Your Lordship. Within last 2 years, they may have
they may have been transferred units.
So you find out, what can I do right now? Await service, list after 2 weeks, when date to be fixed by the rate. In the meantime, you find out, visit the office, go find out.
Lordship,
Yes, next.
Lordship, then respond number 3 only will do because direction was.
No one is here. Nobody is there for R3. Yes.
Wait, please, Lord. In this case, service is completed. Lordship, this is a RSA, the substantial question of law is yet to be found. But today there is some difficulty of my senior, Lordship.
But this has come in orders.
Orders because there is a IA also is pending for operation, stay the operation of the.
Substantial question has been framed.
No, my lord, it has not been framed. Only notice was issued and LCA was called for.
And you have appeared.
Have appeared. I am for the sole response.
So now this matter can be fixed for
Admission.
framing, for
admission.
for framing substantial question.
For admission hearing, my lord.
Mr. Chaudhary, you don't have a right of hearing at this stage.
No, my lord, the petitioner appellant has to satisfy your lordship on this.
That they will.
Yes.
That is between them and the court.
True, my lord.
This
but
is
that will
only
come-
for framing substantial question. Once at the stage of hearing, you will have all the audience to show that the
No,
there
I
is
am
no
not.
substantial
I am
question.
not asking for an audience of hearing. What I think is this.
Generally saying, since you are saying admission hearing.
Yes, my
That's
lord.
why I'm saying. I think this hearing has to be under that column.
Order 41, Rule 11, my lord.
It appears that, heard Mr. H. Agarwal, Learned Counsel for the appellant. Also heard Mr. M. K. Chaudhary, Learned Senior Counsel, assisted by Mr. P. Sharma. Na? M. Sharma. I keep confusing with your initial. M. Sharma, Learned Counsel for the sole respondent.
My lord.
It appears that in view of the appearance of the learned counsel appearing for the respondent, the service in respect of the sole respondent stands complete. It appears that case records as called for has not been received till date. It was called, yes.
Record call for and records have come, my lord.
It's come.
Records have come.
Oh, it further appears that the case records has also been in the meantime received. Let the matter be posted for hearing under, I keep forgetting.
Order 41, Rule 11, my lord.
Under order 41, Rule 11. When?
Anything on which you are watching.
After 2 weeks on a date to be fixed by the registry.
Obliged.
Wait, please, your words. The abatement application is on.
Abatement.
Yes, Lord.
This IA is for setting aside abatement.
Yes, Lord.
Yes, Mr. Borpujari, you have any objection?
My lord, legally, my lord, application appears not to be maintainable under the law.
Why? He doesn't have a, so this is because there are legal heirs.
I am the sole legal heir.
You are the sole legal heir.
Now,
yes,
in the record, I find two applications, two interlocutory applications. One is, my lord, for under Order 22, Rule 9.
Have you filed your objection?
Yes, my lord. We have filed our objection, my lord. So far as IA 1919 is concerned. That is with regard to my lord.
1919, yes.
1919 is an application, my lord.
For setting aside the abatement.
Yes, for setting aside the abatement.
In the contempt petition.
Yes, Lord.
In the contempt.
This abatement in contempt petition.
Contempt petition.
What was the order against which the which order?
Order was, my lord, passed by this honorable court with regard to a status quo. Because, my lord, the partial portion of land, my lord, admittedly, the predecessor in interest, her husband, is the registered owner and pattadar of a plot of land situated near Raj Bhavan, my lord, adjacent to Hotel Bellevue. Now, Raj Bhavan being a high security zone, a decision was taken at the government level, my lord, to widen the road. And thereby, while widening the road, my lord, certain part and parcels of land were cleared up. And they say, my lord, that their land have been transgressed upon, and thereby their valuable right have been affected. In the contempt, accordingly, they filed a writ petition. In the writ petition, my lord, an order of status quo was passed. And in the writ petition, the pleadings have also been exchanged. Complaining about, my lord, that the order of status quo has been blatantly violated, this contempt petition came to be filed, my lord. In the contempt petition, my lord, affidavit has been filed stating that, my lord, after receipt of order of status quo passed by this honorable court, immediately there is a stoppage of work. We have complied. Having come to know the order of status quo,
Immediately there has been?
there is a stoppage of work. They say, my lord, some fencing work is.
Ms. Chaudhary, is this abatement maintainable in a contempt petition? Contempt petitions are between the court and the contemptor.
Yes, Lord.
Petitioner has a very limited role.
Lord.
If the petition, you may appear, that is a different situation, but abatement, whether an abatement setting aside, and this is under CPC.
Yes, Lord.
This proceeding it culminates from a writ proceeding, right?
Yes, Lord.
Writ proceeding.
Yes, Lord.
Yes.
510 order was there.
I have a doubt as regards all the maintainability of your application.
And because
in the contempt petition, you see, ultimately that contempt petition, whether you are there or not there also, the court can go into it once you have brought it to the notice of the court. Then it is between the court and the contemptor. The contemptor has to satisfy the court that there has been no violations. And if the court is satisfied that there is no violations, court will close the contempt.
Absolutely.
If the court is not satisfied, court finds that there is violation, the court will adjudicate whether that violation is deliberate and willful.
Absolutely.
And if the court finds that there has been a deliberate violation, the court will issue necessary orders, right? So how this question of abatement and all this will come there?
Lordship,
What happened in the contempt petition?
Lordship, there was an
petition, it is still
order,
there.
notice has been issued.
Notices have been issued, my lord.
It is here?
Yes,
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 Lordship.
So contempt petition to serve. You have filed your affidavit in the contempt.
Yes, my lord. The respondent number 6, my lord, whom my learned 5, my lord, whom my learned colleague represents, my lord.
First, show me
They
the
filed-
order of the court.
Yes.
Order of the court is at page 18, Lordship.
1-8.
Yes, Lordship. 17, 18. Operative part is at page 18. 16 it starts.
I read that status quo in respect of the land in question.
Yes, Lord.
But what was the issue? Let me just.
This relates to a land in Kharguli area, Lordship. Dag number 4068/458. And then attempt was made to dispossess.
I
the-
shall not take this matter. Not before any other bench without me, huh? The family is
Yes, Lord.
well known to me.
That's it.
My God.
I'm obliged, my lord.
It will not look good.
Yes, Lord.
But Ms. Chaudhary, you look into it, huh? The maintainability of your abatement thing, this is a legal issue, you look into it.
I'm obliged, my lord.
Wait, with the Lord. As per office note, my lord, case is ready regarding service and record. Date may be fixed for hearing, my lord. There's a IA, my lord, for stay. IA 3326. The last order.
Service is complete.
Service complete, my lord. The record has been received.
So this is an RSA.
RSA, my lord.
So the matter can be now posted for Hearing under order 41 rule 11.
Already admitted, my lord.
Substantial questions have been
Framed,
framed.
my lord.
You are appearing.
My lord, one substantial question of law.
That's all right.
Very simple, my lordship may fix up a date, my lord.
Heard Mr. T.K. Bhuya, Learned Counsel for the applicant, also heard Mr. K.K. Dey, Learned Counsel appearing for?
Respondent 1 and 2.
So they are only 1 and 2 only for the respondents. In view of Mr. So-and-so entering appearance, as well as the office note, the service as in respect of the respondents stands complete. It further appears that the case records has also been received.
My lord.
And the substantial question and the RSA has also been admitted. List for hearing 24.
September?
In the month of September, on any date to be fixed.
My lord, till date, my lord, no further proceeding may be state, my lord. Imperial order may be state, my lord.
That is already there?
Yes, no, my lord, no state order is there, my lord. But if the pendency, my lord.
I think your IA, you should have taken it earlier.
My lord, that is why my lord, notice has been issued, my lord. Last date notice issued, my lord.
The IA has come up today for consideration.
Yes, my lord.
IA to see.
Last date, my lord, I was asked to take steps, my lord. Order dated, my lord.
Oh, 8th
19 to 25.
Then why you all started saying it can be admitted and all that?
My lord, main RSA has been admitted. Substantial question of law has been framed.
You want to file your objection here in the IA?
My lord.
Then why don't you say that?
My lord, since my learned friend was not.
May I submit
understand that you have come for the first time after notice has been served on you in the main RSA. That is why I was passing that order. If we don't get this much assistance from the bar, then how do we
may I submit one thing, my lord? If I learn it,
by when can you submit your objection?
In case, my lord, the appeal is fixed for hearing. And
no, appeal is not getting fixed for hearing right now. The matter only the IA. By when can you file your objection in the IA?
Well,
Next week? No, not 3 weeks. Otherwise, I'm hearing it right now. If you want, you can file it within 1 week.
Kindly allow me 2 weeks.
1 week. In the IA, yeah, that earlier order you cancel. Heard Mr. T.K. Bhuya, Learned Counsel for the applicant. Also heard Mr.
K.K.
Dey, Learned Counsel appearing for the respondents. In view of so-and-so entering appearance on behalf of respondents, the service in respect of the respondents stands complete. Mr. So-and-so seeks a short accommodation for filing objection in the interlocutory application. Prayer is allowed. Relist date of the deed after a week on such and such date.
My lord.
Please, well, also in this matter, the service has already been completed and case is ready for admission hearing.
WPC. You are preparing for all?
Yes, 456.
Heard Mr.
P. Thakuria.
P. Thakuria, Learned Counsel for the petitioner. Also heard Mr.
G. Alam for
respondent number
456.
456 and Mr. G. Bordeloi, Learned Counsel appearing for respondent number 2 and 3.
I need 2 weeks time to file my affidavit.
Mr. So-and-so seeks 2 weeks time to file return in the matter. What about you?
Yes, I also filed the affidavit.
Then give both their names and say 2 week time for filing their respective return in the matter. Prayer is allowed. List after 2 weeks on a date to be fixed by the registry. Yes.
May I please, your lordship, because
IA, Mr. Bhuya.
IA is for, my lord, we are apprehending an order, my lord, by which the demolition had been threatened, my lord, demolition of my permanent structure, my lord, wherein I am residing, just for a, my lord, temporary measures, my lord.
Last occasion you are absent.
My lord, unfortunately, what has happened, my lord?
Lordship, will file your affidavit. Some time may be allowed.
You are going to file.
Lordship.
How much time?
Lordship, 3 weeks maybe.
3 weeks. Why 3 weeks?
Lordship, we are yet to actually get our instructions.
Get it.
My lord, in the main rate also no affidavit, my lord.
All right, let them file.
My lord, some protection. my lord,
Yes, you were also absent in
Lord,
on the
this
last
is-
occasion.
It is
Uh,
it is my fault.
Heard
Lord.
Mr. A.R. Bhuya, learned counsel appearing for the petitioner, also heard MS.
A Bodhakur.
A. Bhattakur, learned counsel appearing for the
For appearing on behalf of P. Nayak.
P. Nayak, learned
For
selling counsel,
GMC.
GMC stroke GMD. Stop. MS so seeks a short accommodation to file objection in the interrogatory application. Prayer is allowed. After 2 weeks, they did it. Released on such and such date.
Lord, till then, they may not take any course with action.
Next.
Obliged.
Obliging. Lord.
May please your lordship. In this case, 3 IAs are pending.
Condonation, abatement, substitution.
Yes, for this is respondent number 5. Substitution of the legal heirs of this is respondent number 5.
So right now,
830 days.
right now, first is the condonation.
Yes.
830 days.
Yes.
That's a long delay.
Ground I have mentioned.
2 years, lordship. Above 2 years.
What is the
I have
ground?
mentioned. They have not filed any objection, your lordship.
You're filing objection or you're not filing objection?
I may file, lordship.
Then file. What do you mean by you may? You want to file or I'm not going to force you
Today
to
is
file.
posting, lordship. How can I file?
Huh?
Today is the first day of this.
Today is the first day.
This-
Notice is not issued.
Not-
Lordship, in this case, issue is that.
All right. Heard the MS.
As Tasukta.
S. Talukdar so and so heard Mr.
A. Chalum.
A. S. Salam. Learned counsel appearing for respondent number
1, 2, 3, 4.
1, 2, 3, 4. Mr. K.K. Bhattacharjee, learned
For
counsel
7, 8,
appearing for respondent number 7,
7, 8, 9.
8, 9. Mr. A. Bhattacharjee, learned counsel appearing for respondent number 10. Everybody is going to file objection or only you?
I filed.
Mr.
We are not filing.
Mr. Your name?
A. Chalum.
Mr. Alam, learned counsel, seeks accommodation for filing objection to the condonation application. Prayer is allowed. When? Released after
2 weeks. Lord.
2 weeks on a date to be fixed by the registry.
5.
May I please, your lordship. Lordship, this I is for substitution of the legal heirs of appellant number 1.
54. Yes. Note first time.
No, Lord. Matter is already fixed for hearing.
No, this IA is
I is for
first time.
First time.
Legal heirs of
Legal heir of appellant number 1. Sirajuddin Khan.
you are appearing for all the respondents.
Respondent number 1, Lordship.
What about 2?
Who is not appearing, Lordship?
And who is the legal heir?
Legal heir is at page 3, Lordship.
Notice
One-
has to go to them, I think, first.
Lordship, if the substitution is allowed, then notice will go, yeah. Okay.
You have any objection?
No, Lordship.
But respondent number 2 is not appearing in the main case.
Not appearing.
Some main case too. Yes. 54, I 1076. Heard Mr.
S.K. Gupta.
S.K. Gupta, learned counsel for the applicant, also heard Mr.
A. Hussain.
A. Hussain, learned counsel appearing for the respondent number 1. By way of this petition, by way of this application, under Order 22, Rule 3 of the CPC, the applicant is seeking substitution of the legal heirs of the deceased appellant number 1, i.e. MD Sarajuddin Khan, in RSA number 190 of 2015. It appears that during the pendency of the accompanying regular second appeal, the appellant number 1, MD Sarajuddin Khan, expired on 23/11/2024, leaving behind who is the applicant?
Applicant or the legal heirs?
Leaving behind the applicants.
1 to 5. 1 to 5 are the legal heirs.
Legal applicants who are as under. You will get it at page 3. A to A. 1 to 5, na?
1 to 5, Lordship.
6, 7 and are the other applicants.
6, 7 are the other applicants.
It appears that since the deceased appellant has since the deceased appellant is has been since the applicants in the instant interlocutory application are the deceased are the legal heirs of the deceased appellant, comma, they are entitled to continue the appeal instituted by the deceased appellant. Stop. Accordingly, in the interest of justice, the applicants I 1, 2, 3, 4, 5, the entire names is are substituted in place of the deceased appellant number 1, MD Sarajuddin Khan, in RSA 190 of 2015. Stop. Let an amended cause title be furnished for doing be furnished to the registry for doing the needful. Application stands disposed of, allowed and disposed of. You just reframe that allowed part, put it up, and then say it is a cause title and all that. Okay. And after you have said the party's name, pertinent, just write there. Pertinent that though respondent number 2 in the RSA, does not is though the respondent number 2 though notice in respect of respondent number 2 has been duly received by the respondent number 2 in the RSA 1, in the accompanying RSA. However, there has been no representation on behalf of the said respondent in the regular second appeal proceedings. Yes, 944 days.
We may be permitted to file our objection here.
You want to file objection to
Yes.
condemnation?
Yes, sir.
All right, as prayed for by Mr.
BJ Mukherjee.
B.
BJ.
You are the sole respondent.
There are two respondents.
Who is for two?
I am appearing for two as well. Both the respondents.
For both.
Both.
Mr.
BJ Mukherjee.
As prayed for by Mr. B.J. Mukherjee, learned counsel appearing for the respondents, relist after 2 weeks to enable the respondents file objection in the interlocutory contradiction application.
Deeply objection.
May I please the Lordship? Lordship, the matter pertains to the freezing of my bank account. Lordship, respondent number 1 to 3 has entered appearance. Respondent number 4, notice was served. And Lordship, respondent number 5, I think my learned senior can accept notice.
4 and 5 I will appear. 4 and 5 you are appearing. 5 is a. All right. And what about 1, 2, 3?
Lordship, I am for respondent number 1, 2, and 3. We want to file a affidavit in opposition.
So all the respondents are now appearing. Anyone more?
No, Lordship.
No. Yes. Heard, Mr.
S. Mitra, Lordship.
S.
S. Mitra.
Sorry, S.
S. Mitra.
Mitra. Learned counsel for the petitioner also heard MS.
As they.
As they, learned counsel appearing for respondent numbers 1, 2, and 3, and Mr. R.D. Chaudhary, learned counsels, R.K. Deb Chaudhary, learned counsel, learned Deputy Solicitor General of India, appearing for respondent numbers 4 and 5. Are you also filing return?
Lordship, I have got my instructions.
File it.
Basically, like, these institutions have got nothing to do. Lordship may have a look, Lordship.
I'm not having, you want to file, you file.
Lordship.
Learned counsels appearing for the respondents seek 2 weeks time to file their respective returns in the matter. Prayer is allowed. List after 2 weeks and a date to be fixed by the registrar.
Lordship, may kindly fix it because
It's all right.
Only please, Lordship.
Yes. What is this IA?
IA fellow, but is under order for 39 rule 3, my lord. During the pendency of this, my lord, this second appeal, which is admitted, and there is a stay order. The respondent, my lord, they entered 1 katha land, that is a disputed land, and started to raise the construction. So in that effect, my lord, I have filed a complaint before the Mahabharata police station.
Notice has to go.
That is, my lord, the copy was served to them, my lord, prior to my filing of this case, my lord.
They are not here. Where is P. Sundi?
Yes, my lord. My prayer is, my lord, lordship may call for a report from the, my lord, the police concerned. Because, well, I have filed a complaint before the police also. And, my lord, by this time, my lord, the one restraining order may be issued, my lord, because there is the urgency as per the provision of 3. Because during the pendency of the stay of the execution, he is raising the construction, my lord. The order of stay, my lord, that is in Annexure 1 at page 12. Relevant portion at page 14, my lord. Para 6.
Your prayer is at page 10, Mr. Mohanta.
Prayer is page 10, my lord, yes.
Issue notice to the respondents, and after hearing both the sides, temporary injunctions and status quo. So I'm issuing notice. If
my prayer is there, my lord, that even then,
notice,
if the lordship may concede.
it appears that though Mr. P. Sundi,
yes, madam,
learned counsel has entered appearance for respondent number.
Sole respondent.
Sole or 1, 2?
Here is my lord. One is performer, my lord, probably.
No, but whatever. In the IA, MD Noor Islam is the.
Well, only one, my lord.
Huh?
This is only one, my lord.
One?
Yes, ma'am.
New respondent, huh?
Isu Bali.
Sorry?
Isu Bali, my lord.
Isu Bali.
Yes, ma'am.
Has a. Are you sure the P. Sundi is appearing? Because
yes, yes, on the date of the lordship order, my lord, kindly have a look at the order, my lord. This is annexure one, it pays, my lord.
No, and you do it like
This
this.
from the
issue
order also
notice-
reveals, my lord.
Issue notice, Mr. Mohanta, issue notice, petitioner, applicant is at liberty to serve a copy of the interlocutory application to Mr. P. Sundi, who has entered appearance for the respondent in the accompanying regular second appeal. However, in the event Mr. P. Sundi refuses to accept the notice on behalf of the sole respondent in the interlocutory application, comma, petitioner shall take steps by way of registered post AD within a period of 3 days, 2 days from such refusal through the registry of this court.
My lord,
Relist after 2 weeks on a date to be
My
fixed by
lord,
the registry.
my lord, one prayer, my lord. In view of the, my lord, the affair, these laws. So
Sorry,
lordship-
Mr. Mohanta.
My lord, lordship may call a report, my lord. This is a, the
Let-
lordship can exercise that power, my lord. This is a power is in place, my lord.
Mr. Mohanta, not at this stage.
Otherwise-
Let them be here. Yes.
Master President.
Lordship, the ayes are for substitution, Lordship.
IA 1580 is for substitution.
1580 is for delay continuation.
This, a few of these matters had come earlier.
Yes, your Lordship, day before yesterday.
Then what happened?
Lordship had asked me to obtain instructions if the name of the legal heir needs to be in the respondent column. Lordship, we had filed the IA in the similar format for other cases as well. So, Lordship may issue notice in this case.
This is 69 is for substitution.
1580 is for for delay continuation.
1580
80.
is not even, oh yes, 158. That is for delay continuation.
Yes, your Lordship.
How much time?
608 days.
608 days. And 1579 is?
That is for substitution, Lordship.
And 1581 is?
One is for abatement.
In the delay continuation, you have filed your objection.
No, Lordship.
sir.
We'll serve a copy today.
Huh?
We'll serve a copy to them today.
You don't have got, you have not received a copy.
No, Lordship.
Notice has not been issued.
No, Lordship.
Issue notice. You are appearing for all the respondents.
Lordship, sole respondent
Sole
in RFL.
respondent, Lordship.
Your name?
P. Udagan.
So, MS so and so accepts notice for the respondent. Extra copies within the course of the day, within 2 days from today, list after 2 weeks and a date to be fixed by the registry.
May it please your lordship.
Yes.
Lord, this matter, last occasion, your lordship wanted to see, my lord, the ambit of age determination inquiry under POCSO Act. But I have tried to go through this, my lord. There are several judgments on both the sides, my lord. So, my lord, if your lordship would like to hear today, my lord, I can submit, or my lord, if your lordship would like to hear it in detail, my lord, then that date may be fixed.
It has to be heard in details.